joined early. We appreciate that. We will get started soon. All right, I'm going to leave this up for maybe another 20 more seconds before we get going here. All right. So, and it looks like people are indeed completing this poll question. How do you rate your current knowledge? For the moderating presenter, just let you know, it looks like our audience are indicating their knowledge level. It looks like it's falling between minimal to moderate. So just as a heads up of what people are indicating as their knowledge level, that it's between minimal and moderate here. Okay, well, we're a minute over, and I don't want to impede on our time, and so I'm going to go ahead and close out this poll question. Thank you to the folks who joined a little bit early and actually completed that quick poll question. Again, for those who joined early, I do have a file share that is up that includes the group validation form and also the PDF of today's presentation for you to complete. So that being said, we'll go ahead and get started with today's presentation. So again, welcome everyone, and thank you for joining today's web event, Overview of Special Education Considerations, what juvenile court prosecutors need to know. My name is William Moore with OJJDP's INTAC, and before we get started today, I just have a few items that I wanted to cover to keep in mind. Please note that we are recording today's web event. We will have this, along with other web events, archived on our INTAC YouTube page. If you would like to receive supporting materials related to this and other webinars, please reach out to the OJJDP TTA Help Desk at OJJDP@USDOJ.gov. If you're having trouble downloading the items that I currently am sharing, please be sure to reach out to the Help Desk at OJJDPTA@USDOJ.gov. We recommend for optimal audio, please have the dial out through the WebEx phone line. When you're connected, you should see an icon that indicates that you are indeed connected. If you're having any technical difficulties or experiences, please send a direct chat message to the host. During today's webinar, we encourage you to please submit your questions related to today's webinar through our chat window. To do so, you'll just simply type your question and hit enter. We encourage people to please select in the to line to all panelists. When you select all panelists, we will all be able to see your questions that you are submitting. So again, send in your questions, but please indicate to all panelists. Quickly, if you could, please help us count. We would like to know if you're joining in a group, please indicate the number of additional people in the room with you today. So if it's yourself and maybe your program manager, you would put +1 to indicate that additional person. If you're viewing by yourself or you are alone, there's no need to type anything at this time. This is a quick overview of today's agenda. And now I would like to turn it over for our welcome and introduction of our presenter to Ms. Rachel Larson for today's web event. Rachel, take it away.
Thanks. Good afternoon, everyone. I'm Rachel Larson. I just started working at NDAA as a senior attorney. Prior to that, I was in North Carolina at the Conference of District Attorneys, where I was the juvenile court resource prosecutor for the state. I've been a juvenile court prosecutor in Durham, North Carolina, and maybe more importantly for today's presentation, I started off my career as a teacher, special education and English, and practiced in education law briefly before I became a prosecutor. I want to let the attorneys who are on the line know that we have applied for CLE credit in 6 different states. And so usually once 6 states have approved that, and 3 have so far, you can apply for CLE credit in your state and be granted that. If you have any questions about that, feel free to contact me after the program. And now it's my honor to introduce to you our speaker, Dr. Carrie Mason. Dr. Mason practiced in the PD's office in the National Metro area. She specifically was working on delinquency reduction and as a guardian ad litem, and she worked there prior to joining the Tennessee Court Improvement Program, where she now practices. She also was a special education teacher before going to law school, and she has both a doctorate and a JD. Her doctorate is in special education. So we have someone extremely knowledgeable with us today to present on the issue of special education and what juvenile court prosecutors need to know. Thanks, Dr. Mason.
Thank you. I'm so happy to be here with you guys today. Thank you so much for joining us to learn more about special education consideration for juvenile prosecutors. Before we get started, I wanted to thank everybody who submitted questions in advance. I have reviewed those questions and I hope to answer them in the context of the presentation today. Note that some of the questions that were submitted were about prosecution generally, and as we just went over in the bio section, I have a background in special education, some experience in juvenile defense, but I've never been a prosecutor. So some of those general questions about prosecution are a little outside of my area of expertise, but I do know that the National DA Association has those questions as well, and they want to know what you want to know. So those questions, those inquiries are in their court, and hopefully they'll be able to use those to build trainings to support your knowledge in those areas as well. So thank you so much. So I am here today to talk to you guys about the special education considerations for DAs and prosecutors. So let's begin. Before we talk about special education content, let's talk a little bit about the risks that lead some of our young people into juvenile justice and special education. Of course, abuse and neglect are a danger to the developing brain. I'm guessing that you all know this, but I believe it's important also to conceive of the scale of the risk that faces some of our kids. And to rise above that adversity can be a heavy burden for our young people. And why do children, develop the problem behavior that leads them down into the path of juvenile justice? In part, it's because of the way some children develop in light of the circumstances that they face. We know that children exposed to significant adversity develop executive functioning deficits, like working memory issues, issues completing tasks, issues with regulating their emotions, managing anger, and also managing their impulsivity. That statistic above, that's child abuse and neglect, increases the risk of any arrest of a juvenile by 55% and committing a violent crime by 96%. You see that these children are, in some cases, dealing with adversity that has shaped them or has helped contribute to their behavior, and that's an important consideration for prosecutors and for lawyers that represent children in juvenile justice. So child welfare involvement, as Rachel indicated at the beginning, I work for the Court Improvement Program. Part of what we do is focus on the needs of kids that are in foster care. That's a population that's very close to my heart and probably is part of the work that many of you all do on the call today. For some young people who've experienced neglect and abuse, that experience leads to the added trauma of removal from their family of origin and placement into foster care. These removals are often necessary, and they serve a larger safety purpose, certainly. But foster care is rarely unaccompanied by a trauma that's all its own, as you might imagine, for a child that's leaving their home and entering foster care and the home of a stranger. That can be very traumatic, and for kids in care, it's just an added piece of the burden that they carry. So the hardships add up. In school, children in foster care are 2.5 to 3.5 times more likely to be identified for special education. And that statistic's been borne out again and again. There are different studies present varying degrees of special education proportion, but all of them indicate that children in foster care are much more likely to be in special education. And this is the range than their peers that are not in foster care. A study by Shape and Paul at the University of Chicago indicated that about half of youth in care had experienced arrest. So they have kids in care in particular, those kids that have experienced adversity to that degree have issues and have risk that manifests in school and in the community. And that's an important consideration also for the work that we do. Okay, I wanted you all to just consider for a moment when we're thinking about kids that are in juvenile justice, about how many kids that are in juvenile justice that are committed to juvenile justice facilities, just in your head, just conceive of a number. How many of those kids do you expect have a diagnosis or a disability? What would you guess that percentage is? If we were in person, I'd be taking answers, but of course we are not in person. So I just want you to think of that number in your mind, if you would. And then, see that the number, of course, across studies, this number varies also, but about 60 to 70% of the delinquent population overall has a disability, according to various studies. And for kids in out-of-home care, that number is higher. And also for kids in out-of-home care, the academic achievement levels are also far lower than their peers that are not in facilities and not in juvenile justice. That first citation under the achievement statistic that's noted on the slide is based on my dissertation research. I went into facilities in Tennessee and measured the mathematical achievement of students that were incarcerated there. And it's something to see that with your own eyes. These kids are not prepared for independent living on average. The students that I studied were about 4 grade levels behind, some far, far further behind than that. And when you think about that lack of skill, that skill deficit as children move towards adulthood, it's alarming that we need for kids to have those basic skills to be successful and independent. And for many of our kids, they're just not reaching the mark, and they need more support to get to that mark. So when we talk about risks in education, we have that manifestation. When we talked about in that earlier slide, I talked to you about the executive functioning deficits. I talked to you about the emotional regulation issues and about impulse control. You can see over the course manifesting over the course of a child's educational experience, these different facets that will come to the front: impaired cognitive ability, memory difficulty, poor social skills, language development. Kids that are involved in juvenile justice have a far higher rate of language impairment as well, and that's been borne out again and again in studies. An increased likelihood of mental health diagnoses. So we see that in this population. The Brain Builders video that's linked here and will be popped into the chat. We really don't have time to watch a 5-minute video in the presentation today because we have so much material to cover, but it's a great illustration of why that risk can manifest in a child's life, how that happens, what children need in early development, and what happens when they don't get what they need in early development. So I would encourage you to watch that. I understand it will be popped into the chat. Watch that at your leisure. It's from the Family Wellness Center in Alberta, and it's really well done. We use it a lot in our presentation around childhood risk and adversity and the manifestation of that risk. Okay, so what can we do? We talked a little bit about why we're where we're at, why kids are dealing with the issues that they're dealing with. Well, what can we do to help? And that's what I want to talk to you all about. What we can do is we can keep kids in school. According to educationdata.org, that's an organization that examines publicly available governmental data on education from state governments and federal government, and from the federal government, examines educational graduation rate data. We know that young people that drop out of school are more likely to live in poverty, more likely to develop health conditions, more likely to become incarcerated. Girls that drop out are more likely to become single mothers. Young people that graduate from high school, on the other hand, make more money, have better life outcomes. It's imperative that we keep as many of our kids in school as we can. Graduating from high school reduces crime. It's children or young people that graduate from high school that earn a high school diploma even after dropping out. So kids that are able, or young people that are able to connect to high school graduation or back to their education after leaving school, reduces their rate of offense later in life. So education is really a connection to better outcomes. And of course, that serves the young person and all of us in society as well. As long as we can connect kids to better outcomes and independence, we're serving the greater community. And so it's in everybody's interest that we do what we can to support that life outcome for kids. So how can we help support? For some of our kids, they're facing such adversity and such obstacles as the ones I went over in the presentation so far. What interventions are out there to connect kids to this opportunity for graduation, this opportunity for better achievement, for skills that might support an independent future? The Individuals with Disabilities Education Act is the federal special education law. It's my bread and butter. I've worked in special education since I graduated from high school. Just about. I worked in group homes and undergrad, and I taught special education. My bachelor's, my master's, and my PhD are all in special education. I know about the promise of special education, and I'm excited to share some of that promise with you. Now, certainly special education is not a cure-all. It requires, a lot of talented individuals that are implementing intervention to support kids. But it can offer a connection to school, a connection to people, to caring adults that can make all the difference in the life of a child. So the pillars of the Federal Special Education Act, or the federal law, the Individuals with Disabilities Education Act, are child find. That's under identification and evaluation of children. There is the IEP, which is the written document that provides what the educational program entails. Free appropriate public education. Every child with an IEP is entitled to a free and appropriate public education, and that's sort of defined in the IEP. Education in the least restrictive environment. Children with disabilities should be educated with their peers to the greatest extent possible. We don't want to segregate kids that have disabilities just because they have a disability, although children have a right to make progress in their school settings, and the public education system is not one size fits all. It should be individualized, and some children need more and less support, and there should be a continuum of educational placements to offer that support depending on what a child needs. The idea requires parental and teacher participation, and there are also procedural safeguards. Now, I'm going to go into all of these in a little more depth. I also would be remiss if I didn't mention something called Section 504 of the Rehabilitation Act, which some of you all have probably heard of. We don't really have time to go into this other federal statute that relates to children with disabilities in school as well, but know that Section 504 of the Rehabilitation Act is a federal civil rights statute that provides access and accommodation for children with impairments. It provides some disciplinary protection that I will talk about at the end of this presentation, but for your purposes, the children that you're seeing in your courts are more likely far more likely to be served with an IEP under the IDEA than a 504 plan under Section 504 of the Rehabilitation Act. I think the numbers, I looked at them briefly before this presentation. About 12% of kids in the public schools have an IEP under the IDEA, the Individuals with Disabilities Education Act, whereas about 1.5% of kids in the public school have a 504 plan. So, and it disproportionately serves higher income kids. Section 504 does. So another reason why you're less likely to see it in your courtroom. And there's a lot of reason for that. I did want to drop in, if you are very interested in 504 and the difference between 504 and the IDEA, I wanted to drop a citation in the chat of one of my mentors, one of my earlier mentors, in grad school, and that is Dr. Perry Zerkel, and he's at Lehigh University, and he writes on Section 504 often. His scholarship is well known in that area, and I'm trying to see if I can pop into the chat, and I don't know that I'm able to, so I may have to give you that that link after we finish today's presentation. Yeah, I'm not able to get into the chat. I'm not sure why. I'll make sure you get the citation for Perry Zerkel after this session today, and you will be able to use that to answer all your questions about Section 504 of the Rehabilitation Act. So back to special education under IDEA. I'm really glad that you all are here to learn more about that. As prosecutors, I know that means that you're here to figure out how you figure into this ecosystem where we're serving kids with disabilities. It's a great reminder that we're all in this work together to support the needs of kids in care. And I appreciate you. I appreciate that you're here. I appreciate that the National District Attorneys Association asked me to talk about this with you. We're grateful because it's going to take a village, obviously. It always has and it always will. So going back to those pillars, that first pillar I talked about was child find. So child find is that requirement that schools go out and find children with disabilities. They have an affirmative duty to identify children with disabilities, locate them and evaluate them. They need to be trying to figure out what's going on with a student and if they need to support a student in school. The issues that we're looking at in terms of whether a child is suspected of having a disability and needs to be evaluated is academic performance, but not just academic performance. Also, criteria that individuals should be taking under consideration are, of course, behavior, attendance, communication concerns, and mental health concerns. Usually that information, that concern, that suspicion is communicated to the schools through a parent concern. Sometimes it's a teacher concern. A teacher says, I think there's something going on here and raises the suspicion flag. That child find affirmative duty applies to homeless children, to highly mobile children as well, homeless children and children who move frequently, such as children in foster care or migrant children. Okay. So just the takeaway there is just recall that grades are not the only factor that the school has to take into consideration. I think that's a common misconception when we think about children with disabilities. I think in the work that we all do with the kids that we all work with, we all know children that have behavioral issues, problem behavior that may interfere with their education, and that child may be a child with a disability as well, even though a child may be maintaining passing grades and moving from grade to grade. There's always more to the picture. Also, children that miss school a lot, as I said, may have something else going on that may require a deeper look. So decreasing risk through special education intervention. The starting point, where do we start? Usually we start with a referral from a parent or a teacher This may be an email or a letter requesting a closer look, more support, or a special education evaluation directly. I was asked whether a juvenile court could order a special education evaluation. Say a judge has a child before the court that has some obvious learning problems, challenges, requires more support at school. Maybe the offense that brings the child to the court occurred at school, and it becomes clear to everybody the child isn't getting the services they need, and the child doesn't have an IEP under the Individuals with Disabilities Education Act. So the court knows what needs to be done. The court says, I order this child to be evaluated. That is potentially not going to be as effective as getting that child, getting the parent of that child a letter requesting an evaluation for special education. And that is because under the IDEA, parental consent to evaluation is required. Schools have to get consent to evaluate under special education. And the IDEA also defines consent. And under 34 CFR 30.9, that consent must be voluntary. So a court order for a special education evaluation won't work without the parental consent piece, the voluntary parental consent piece. If the parent consents, it's not an issue. But if the parent doesn't consent, then the school has other means that it can pursue, other recourse to get that child evaluated, but it's all very explicitly defined in the IDEA, and it requires administrative procedures, not juvenile court procedures. So I would just advise you, and I'm going to include those links again. If I could access the chat, I would, maybe I can access the chat. I'm going to drop those citations for you in the chat so that you have them. And again, we can't cover everything today, but I want you to have access to information about this topic if you would like to know more. Okay, those are the links that you need. And I'm going to come back to Perry Zirkel at the end, so I will leave the link to his website at the end when we get back to Section 504. So don't worry, Perry Zirkel, that link will be in the chat because he has a last name that can be difficult to spell phonetically. One of the things I did want to cover is about that parental request for evaluation. Of course, the parental request is the most typical means that that evaluation referral comes into school. And sometimes the parents that are working with our kids aren't quite sure of the hoops they have to jump through to get from a concern about their child to an evaluation for special education. I wanted to provide you all with this link, which is from, this is an example of a parent request for evaluation with some fillable blanks. It's really easy to use. Now it includes some language from the Michigan special ed law. The timelines regarding evaluation under the IDEA are the federal floor. You all are familiar that with the federal laws, the floor, and state laws can provide more protection for individuals. And so the Michigan letter that I'm dropping in the chat now provides a great sample, but includes some very specific Michigan timeline information. So just use this as a model. What I like about it is it has blanks that the parent can fill in with a pen. They can say, this is my name, this is my child's name, these are my concerns, and this is what I want. And it's very easy to use. It's something that I think a juvenile prosecutor, a judge, a juvenile defender could pass to the parent and say, fill in the blanks, read it over, and submit it to your school principal. And then you started the process for special education evaluation. As I said earlier in the presentation, just a few slides ago, That's going to start with a meeting at the school, a support team meeting, to figure out whether other interventions are needed or whether we need to go right to special education evaluation. If a parent, insists on evaluation for special education, the school generally is going to provide that unless there's a real good reason not to, like there was just an evaluation last year and the child wasn't eligible, and, certain circumstances like that. But generally, the school will do that evaluation if the child is suspected of having a disability, and that letter is a way into that process. That letter, signaling suspicion, also provides that child some disciplinary protections at school, which can be critical to keeping that child in school. So it's a great start for a child that is suspected of having a disability. And again, I just want to say, and you all probably hear this sometimes in your work, it's not really a workaround. If you've got a child with a disability that's been caused by some issue in early childhood or some organic issue, that child needs access to accommodations, modifications, and specialized instruction that have to be provided. The public schools serve the public, and we take the public as we find it. We're not only serving, a certain kind of the public. We have to serve this general public. We have to serve all our kids. And by serving all our kids, serving ourselves, we're providing access to that link to independence that children desperately need and our society needs for them to have. So that's the process. So you have that letter that you all can use as a model and make your own adjustments, make more lines maybe for how a child, what those parents' concerns are. But it's a great tool. And I was really pleased to have found it. It's from the University of Michigan. And I'm sure they'd be delighted to know that folks are encouraged and supporting parents and kids with it. So eligibility. So we talked a little bit about that request for evaluation. What's happening on the school side as a school gets a request for evaluation when they're looking at eligibility under the IDEA? So we know a parent has the concern, or maybe even a teacher has the concern, but how do we know if a child is truly eligible under the Individuals with Disabilities Education Act? Well, number one, we have eligibility criteria, which I'm going to talk about in a minute. And number two, the child has to also need special ed. Not every child that has a disability requires special education. Some children may have, for instance, attention deficit hyperactivity disorder, ADHD. You may have a child that has ADHD and maybe some impulsivity, maybe a problem focusing, but you know what? That child is doing okay. That child doesn't need an IEP. The child is still performing well, coming to school every day and not getting in trouble any more than any other child is. So not every child with a disability will require special education, but some will. And that's part of the criteria for special education. Again, the criteria is more than just grades. We're also looking at attendance and behavior. The 13 categories of eligibility under the IDEA are listed here. For our purposes, I would draw your attention to emotional disturbance, ED, other health impairment, OHI, and specific learning disability, SLD. Now, those are called different things in different states. This is from the federal statute. This is from the IDEA. States are able to take these terms and call them what they want to in their state law. Here in Tennessee, we have ED. When I was a teacher in North Carolina back in a long time ago, we used the term DED, behavior and emotionally disabled. And you'll see some variance in the terminology across states. And but it's still the same federal floor, the federal definition that they're using to identify students under these eligibility categories. So emotional disturbance is one of the big ones that you see in juvenile justice. Kids with disabilities in juvenile justice related to those early adverse experiences develop sometimes these behavior coping skills that don't serve them quite as well in school as they maybe serve them at home or in the community. So emotional disturbance is defined as the condition with one or more factors that adversely affects the child's educational performance. And so you can read these. What I see, having served kids with at risk for juvenile justice or in juvenile justice for a number of years, what I have seen, my clients, what I have seen in my students is very often this third bullet: inappropriate behaviors or feelings when no unusual stressors are present. So a child that has that emotional dysregulation issue, that disproportionate reaction to a circumstance, that anger control issue, that's what you see very often with ED, emotional disturbance. But it can also be that inability to maintain relationships. Children that just can't find that close connection at school, that may need support and instruction to make that connection at school, because we know having that connection at school can be that child's saving grace. Also, children that have depression. ED isn't just a category of eligibility for children that have anger control issues. I've worked with kids with ED that also have, they're known as internalizers, children that have a hard time managing their anxiety and maybe don't lash out at school, maybe feel all that distress internally. And they may qualify for ED too. They would require definitely a different set of interventions and programs to support them than, you know, a child with externalizing behaviors, with acting out behaviors. But they would both potentially fit under this eligibility category. Other health impairment. So other health impairment is the eligibility category that captures a medical health diagnosis that manifests in a way that affects the child's school performance. Other health impairment, typically, I don't know what the proportion is, but a large number of kids that are identified as other health impaired have ADHD, attention deficit hyperactivity disorder, as their underlying diagnosis. And so that ADHD then qualifies that child for the medical diagnosis of ADHD, will qualify that child as having a disability under other health impairment category. And so the criteria is limited alertness at school, and specially designed instruction is required because the child may have organizational skill deficits, unable to complete tasks, health-related absenteeism, or may take medications that also affect cognitive functioning. It requires that diagnosis by a medical provider. So while that other health impairment eligibility may rely on a diagnosis of ADHD, there are other diagnoses that also may support eligibility under other health impairment. And ADHD is just one of them. But any health condition that affects a child in the ways that are listed above, I can see that epilepsy could potentially qualify a child for OHI. In my work with kids at risk or involved in juvenile justice, I think I've only ever seen other ADHD support that other health impairment diagnosis. But certainly it's meant to capture more than that, and it does. I just only work with the population of kids that I think all of you all work with too. So this is the one that you'll see the most. And of course, specific learning disability, which isn't included in the slide, but includes a child's inability to learn a specific content area. And there's a whole push around response to intervention. Schools are going to try and figure out first if there's been a lack of instruction and if a child is able to make progress with quality instruction first before that identification label is included. And it's that's response to intervention, specific learning disability. Is that category. We used to see specific learning disability identified more frequently than we do now, and now there's really that push to intervene using general education, instruction, and interventions to support kids to get them caught up. So the evaluation process. Evaluation occurs when a child's suspecting of having a disability in all the areas of suspected disability. So we know our kids don't necessarily come to us with just one possibility for eligibility. Some of our kids have multiple issues. They might have ADHD, and they might have a learning disability, and they might have an emotional disturbance. That happens. I've represented kids like that with more than one, the primary area of eligibility, a secondary area of eligibility, and a tertiary area of eligibility. So our kids are really complicated. And so that evaluation should be going into every area of suspected eligibility. And in that letter, that sample letter that I included in the chat, on that blank, that parent wants to write in all that area, all those concerns about suspected area of eligibility, so that they all get evaluated, so they all get tested. Also, in that meeting, when they come together to talk about how to address the parent's concern, and they talk about potential areas of suspected disability, the parent wants to, the parent wants to bring up all those concerns in that meeting as well before they sign consent for evaluation, just to make sure that everybody's on the same page about what those parent concerns are. Evaluation team needs to get that signed consent for evaluation. Again, that signed consent is required under the law. If the parent won't sign consent for evaluation or refuses consent for evaluation, there is a process the school system can follow that's laid out in the federal law. There's a 60-day timeline for initial evaluation under the federal law. Now, and again, the Michigan letter includes a shorter timeline. The states can provide more protections for individuals than the federal government does. And in that case, Michigan did or does. So a comprehensive evaluation should be in a student's native language, that language that the child's able to speak, so that we're able to be sure that we're getting an accurate measure of that child's ability, and then conducted within 60 days of parental consent, or the state's timeline, as I said. So eligibility. So the eligibility for IDEA is determined by a team of people. There is the school psychologist typically is performing the evaluation, gathering the information needed, which is generally going to include, an IQ, an intelligence quotient as measured by, one of the IQ tests that we know is valid. And so the student will take all those, we'll take an achievement test, we'll take an IQ test, we'll do, depending on the area of suspected disability, maybe taking measures of adaptive skills, like their self-help skills, if they're suspected of having an intellectual disability or some other issue that's, developmental in type. And those measures are taken typically by the school psychologist, and then, or in support of the school psychologist for children with the suspected emotional disturbance. There's also a number of rating scales that the parents will fill out, but the school psychologist will make sure that the parents get that information and they're filling out those rating scales, and that the teachers are filling out those rating scales so that they have a good idea of the behavior and emotional measure of the child. And so the school psychologist is putting together this evaluation package. And this evaluation then will include usually a recommendation regarding whether that child meets the criteria for the eligibility category. And then it's up to the team to decide what to do with that information. So the evaluation goes part of the way, and then the team has to go the rest of the way. The team has to say, I see that the child meets this criteria. Do we think the child needs special education? And so the team decides together. The parent is an essential component of that team. Now, parents are generally very responsive and very engaged in their children's education, but sometimes schools have to reach out more than once to make sure they get that parent to the table and think outside the box in terms of how to get that parent to the table to go over that evaluation result. And may help make that decision about whether the child qualifies for special education. At the end of the day, schools are not able to serve a child in special education without parental consent. There's no override in the law in the way that there's an override for evaluation for special education. Again, there's no override for services. If a parent goes through this evaluation process, can see that their child qualifies as part of this team that everybody says, the child qualifies for special education. If the parent disagrees and the parent doesn't want that child to receive special education, there's no override to provide special education services. That's just the way that the law is written. And then you have the citations for the idea earlier in the chat. I put them in about 229, so you can review the idea to find the specific regulations on point as far as that goes. But yes, there is no override. Parents have to give consent for services. So what do those services look like? The IEP, you probably heard about it. I've said it multiple times so far. The IEP stands for the Individualized Education Program. It's a plan that comes together to serve the individual needs of the child. In that IEP document, according to the IDEA regulations, you're going to have a child's strengths, the parent's concerns, special factors, which can include behavioral concerns, present levels of performance. In terms of an initial evaluation, you're going to have all of those present levels of performance right in that evaluation. You're going to know what that child's achievement is, what that child can do. There'll also be behavioral observations that are in there, that are in that evaluation and that are provided at that IEP meeting to develop that IEP, so you know how the child is functioning across domains that are relevant to that child's disability. Then there are goals. What do we want this child to be doing in a year's time? Accommodations, modifications, a transition plan for children that are approaching adulthood, and related services planning for children who need related services. Special education must be provided in conformity of the IEP for the federal law, and it must be reasonably calculated to ensure the child is able to make progress. And that is from the fairly recent Andrew F. decision decided by the Supreme Court. So behavior, a lot of our kids demonstrate problem behavior at school related to that ED eligibility category, and also that OHI eligibility category, or also not related to an eligibility category just because they demonstrate problem behavior. The IEP can address that problem behavior if that student's behavior interferes with his learning or the learning of others. And so that's a great tool to program for behavior. Schools can be providing support to kids that need it, and they can do this through the IEP and also through a tool called the Functional Behavior Assessment and Behavior Intervention Plan. The Functional Behavior Assessment, it really drills down into what's causing that student's behavior, what's happening before, during, and after, and how can we intervene on that behavior to stop it from happening at school. It can be very specialized. A lot of school districts employ board-certified behavior analysts that are conducting these assessments, and they are wonderful when they're well done. Sometimes they're conducted by teachers that haven't had enough training to really do it the way that will really shift a child's behavior. And when I always tell teachers that are in a position to have to create functional behavior assessment and they haven't been trained to ask for help, you want those teachers to be able to ask their administration. Most school districts have, even if they don't have a board-certified behavior analyst located in school, they might have them in the district. And so you want to ask for that help around behavior support, because it is I think the most critical tool for kids with problem behavior is that functional behavior assessment that then guides the behavior intervention program or the behavior intervention plan. And so the school systems are required to consider positive behavior intervention. That's because the research says positive behavior intervention works a lot better than punishment. And that's been borne out again and again. You guys have probably heard about manifestation determination review. That relates to school discipline. Problem behavior, of course, is one end of the line that ends in school discipline for children with significant problem behavior. And so the manifestation determination review process is laid out here. Some places call it manifestation review. Some places call it MDRs. It's a process for students that are recommended for a disciplinary change of placement, and that is, under the law, expulsion or a long-term suspension over 10 days during the school year. And those can be cumulative, added together. So if the student is on their 11th day of suspension. So it's for a student with an IEP or a student without an IEP when the school has knowledge. And I told you earlier that there's a disciplinary protection for kids that have that referral that is suspected of having a disability. So if a parent has given a school that letter that says, I think my child has a disability, then they are entitled to the protection of the idea around manifestation determination review. The question asked is, was the behavior caused by the child's disability, or it bore a substantial relationship? Or is it because the school didn't implement the IEP? You know, did the student have a certain provision in their IEP providing for one-on-one site supervision that wasn't being implemented? And did that child then, you know, leave campus and cause a problem when they weren't, you know, nobody has eyes on them and they were supposed to? So if the school isn't doing what they were supposed to support that kid and that environment they were in, then we would say it was a manifestation of the student's disability. It was a manifestation of the failure to implement the IEP, and then the child's entitled to specific protections. These are the requirement around rules, around timing. The team should include relevant members of the student's IEP team. It doesn't have to include everybody, but should include folks that are engaged with the child, school psychologists that can interpret the evaluation, and the teachers that serve the child, and of course the parents. If their child works with a mental health professional, we always want to make sure that they're invited too, because they have specific information about how that child's disability may manifest in that particular individual. And so they make that determination. If it is a manifestation of the child's disability, that problem behavior, then the child can't be expelled or long-term suspended unless the parents agree that's what they want to see happen. There are some exceptions. I'm going to talk about those real quick, but just know that schools aren't left, without tools. They then have to create this functional behavior assessment, this CIT. They have to serve their kids where they find them, and sometimes that's really challenging. It takes a lot of planning, and we may need then to bring in that board-certified behavior analyst, that behavioral expert that can help support positive behavior change for that kid. Special circumstances. So those rules don't apply around the bar to removal if special circumstances exist. So that's when a child brings a weapon to school. Now, a weapon is defined in the idea, and it includes, a knife over 2.5 inches. It includes, any sort of serious weapon like that. Also, drugs, serious bodily injury. In that case, the child may be removed for not more than 9 weeks, 45 school days, regardless of whether or not it's a manifestation of the disability. And if the school needs to extend that timeline, they're able to through the provisions in the idea. It's a process, but they can keep their children safe. There's also, what I said in the beginning about least restrictive environment, it's not one size fits all in the school. Some of our kids need a lot of support, and a lot of support may have to happen in a setting that is very specialized and is not the regular classroom. Our children are entitled to make progress. The Supreme Court's told us that. And if they can't make progress in the regular education setting, we have to try and figure out a setting that will work for them, that will allow them to have access to the supports they need so they can make progress. I told you I'd come back to Section 504 at the end, and this is what I'm doing now. And so that is my prompt to myself to get you the information for Terry's or Cal. Okay, so under Section 504, there is also a procedure to determine whether the behavior was a manifestation of the child's impairment or disability under the 504 plan. So if you are working with a student or on behalf of a student that has a 504 plan, know that there are similar protections under 504. They're not written exactly the same. The statutes are different, but they require an evaluation to figure out whether the behavior was caused by that child's impairment. And if it was, the school system has to serve the child. And that's a disability, equal access protection. You can't punish a child for the symptoms of their disability. We have to figure out how to serve them. And that is what that stands for. And you have Terry's or Cal's link. He writes a lot about Section 504. And so you'll find all the information you need there. And that is my last slide, I know that we have some questions coming in. We have a little time to open up.
Hey, yes, we have lots of questions. Let me ask first, I have a question here. In the juvenile justice system, whose role is it to ensure a student receives a free and appropriate education when they are in custody and or retained in juvenile facilities?
That is a very good question, and I have another link I want to add into the chat about education and juvenile justice settings, because children are entitled to a free and appropriate public education in juvenile justice settings, and I'm so glad you asked that question. Such a good question. I would encourage you to read the material that I just dropped in the chat around free and appropriate public education in juvenile justice settings. It's so important. Our kids are assets over there, and it's really they're at the end of the line in terms of pro-social behavior. We've got to intervene as strongly as we can. It's not the time to turn away from kids. We really need to push intervention, even in facilities, and that can be challenging. But a great place to start is just the literacy, using math skills. Like we have to get at those academics too. We know our kids are so far behind.
And we have another question here. What if the parents' whereabouts are unknown and parental rights have not been terminated? How can a child get an evaluation under these circumstances?
So for a child in care, for a child in foster care, if the parents are unknown, that's probably going to be the child that maybe the Child Welfare Agency has taken control of. Because if the child's going to school every day and looking for the parents on, then I would say a referral to the Child Protective Services maybe. And so in those circumstances, for boards of the state, there's specific provisions in the law for appointment of what's called a surrogate parent that can make those educational decisions for a child. As guardians ad litem, we often will serve as surrogate parents for their clients. Also, school systems have an obligation to appoint surrogate parents for kids that have parents that are unknown or unfindable. And those provisions are all in the idea. And in that citation I provided at the beginning, you'll find the provisions related to kids in foster care around that surrogate parent.
Great. Another question here is, many parents are averse.
Rachel, my apologies. Sorry to interrupt here. If you could, when Carrie answers the question, could you just mute yourself just to kind of cut down a little bit of the feedback there? Sorry to interrupt there. I just wanted to make sure people can hear our answers clearly there. Thank you.
Thank you. Many parents are adverse to having their child labeled as having a disability, so they will not give consent for an evaluation. What can be done in those circumstances?
So as I said earlier in the presentation, the school system does have the ability to they have recourse when a parent refuses evaluation. They can do something called file a due process to require to get that court supervision. It's administrative court, not juvenile court, but to get that administrative supervision on eyes on that case. And an administrative law judge can require that evaluation, but nobody can force a parent to consent to services if that parent does not want that child to receive special education services under the IDEA. It's just the way the law is, and the school can't be held responsible for not providing services if the parent has declined those services, if the parent has refused those services. And that's just the way the law is. And for some kids, I know that's a heavy burden. For parents that's just concerned about that label, and they're missing out on all this other stuff. And so I spend time talking to the parent, or if you're connected to, the parent's attorney or someone that has some relationship with the parent, encouraging the parent to see the situation from all sides. Understanding the disciplinary protections of IDEA, like these special education laws help keep kids in school in certain circumstances when it's in their interest and because of their disability. And so that's a really important thing that parents need to realize they may be giving up when they don't consent for services.
Dr. Mason, I've seen in my own experience a judge call in the school districts because they, for example, a juvenile appeared in front of them. who couldn't read and they were 16 years old. And the judge basically issued a show cause order, the school system to come and explain why they shouldn't be held in contempt of court for their failure to provide education to the child. What do you think about something like that?
I mean, I think that's interesting. In Davidson County, Tennessee, in Nashville, where I work, the juvenile court will sometimes do a similar thing, especially around attendance issues. When you've got a child that's not going to school and there's truancy issues, but the child's not going to school because the child, has all of these obstacles and barriers at school. And so, the judge will subpoena will order the court or the school officials to come in and sort out the issues before the court. I think it's an interesting strategy, and sometimes it's what's needed to kind of put the pieces together for kids. Our kids are complex, and sometimes, the right hand doesn't know what the left hand is doing, and so on. And so sometimes that may be what ties the pieces together and gives that kid that safety net that's so needed in school and at home.
Just a couple more questions. Our time is dwindling a little bit. There's a question that we received ahead of the webinar, which is how can community organizations prevent special ed students entering juvenile justice in the first place?
So, for children that are in foster care, children that are engaged with the child welfare agency, the child welfare agency is required to extend reasonable efforts to support that child's, well-being and connection to be able to return home at some point or to be safe in an adoptive setting. And so those reasonable efforts can also include psychological services to support mental health and wellness. In terms of kids that are not in foster care, children that are not engaged in the child welfare setting, there are school social workers at school, and that is for children that have IEPs. That is a service that can be provided on that individualized education program. If a child has behavior and emotional issues that cause that child not to make progress in their education, then those issues can be addressed on the IEP. And so that's one way to compel services that can actually be happening during the school day. And community service providers sometimes are engaged during the school day, for those schools that have school-based mental health. And then they can, of course, follow the child, and their families over the summer and so on and so forth. And other providers in the community, that's, there may be a connection through the court or through parent education.
Great. And I'd like to add, if you're not familiar with the School Justice Partnership, that's an agreement between law enforcement and the school, and sometimes even the prosecutor's office, not to pursue cases that come from school. And the stakeholders can get together and define the criteria that they use for not sending cases from school to juvenile court. So that's something you can work in your own community around. Sometimes it's the first fight at school won't be referred to juvenile justice, and I'm sure that other criteria could be involved. I'm sure there's confidentiality issues around IEPs that may be played. In fact, do you see any issues around a school justice partnership agreement, excluding, certain IEPs like behavioral IEPs from being referred to juvenile justice?
What we, in Tennessee, we have the Behavior Supports Act, which provides, it's an example of a situation that provides extra protection for children with disabilities with regard to law enforcement. And the Behavior Supports Act in Tennessee provides that if a child commits an offense at school, before the school system can file a juvenile petition against that child, they have to do a manifestation determination review, just like the federal law provides for suspension and expulsion. And so in that case, if the school determines that the offending behavior was a manifestation of that child's disability, they can't file a juvenile petition. Now, a private party still can file a juvenile petition related to that offending behavior, but the school itself can. And so there's that level of protection for kids around that specific issue, around symptoms of their disability, which is, in Tennessee, is is great. It's an understanding that that problem behavior may arise out of something that the child is working on at school, and that everybody knows the child is working on at school. It may be a signal to the folks on that school setting that we need to look at better services or more intensive services or maybe more supervised settings. Like there's that signal to them that, you know, we may not be getting it right now, and we may need to be doing more. And the juvenile justice system doesn't even want to hear about this right now because we need to be doing, you know, our part over on this side. And so let's figure that out. Let's bring in this board certified behavior analyst. Let's bring in, you know, this person, this consultant. Let's bring in this mental health expert. Let's get this kiddo what this kiddo needs so that we can keep them out of juvenile justice and adult justice systems as they get older. Oh, I think you're muted.
I have one more question here, and I'll check the chat to see if we have an additional. But this question is, how do special education considerations come into play when putting a disposition together?
So that can be, you know, when you're putting together a disposition, you want to take into consideration what a child is able, you know, to do. And I think that it's relevant. I think that the folks that are engaged in that process with the court need to have, you know, a knowledge of what services are going to be available and what they're meant to do. You know, for instance, I've worked with kids with IQs below 70 with language impairments involved in, you know, CBT, cognitive behavioral therapy. And for some of those kids, it was real hard to access services in that sort of a setting when really applied behavior analysis would be better for a child that is got a limited intellectual functioning, for a child that doesn't have the ability to verbalize all of their you know, feelings and don't have maybe that insight into their behavior. ABA may be a better tool for behavioral change, and ABA, applied behavior analysis, is the foundation for functional behavior assessment, and so it's well supported in the research. And so I think in that way, you know, we have to be thinking about services that are going to hit the target. You know, we don't want to be wasting resources. We know it's evidence-based, and we know it's evidence-based for particular populations. And so we have to be able to take those considerations, you know, to factor them into the child's disposition.
Concerns I've heard regarding dispositions are, for example, that a prosecutor, or rather the judge, orders that juvenile must complete high school or GE equivalency in order to come off supervision. Do you have any input on dispositional orders like that, and if they're appropriate for students with an IEP or profound learning disability?
Yeah, I mean, that can be, that's gonna rely as much on what services are available in the school. In many states, there's more than one type of diploma a child can access. You know, I know that you recently moved from North Carolina, and I taught in North Carolina as well. North Carolina has something called the occupational diploma for kids with disabilities that looks just like a regular diploma. It is a regular diploma, but the transcript is different. They're taking different classes to access that diploma. And so it would be wonderful if our judicial officers were really educated on all those possibilities for children to receive a diploma. Again, you know, the curriculum is not one size fits all. The curriculum available at school is not one size fits all. And in Tennessee, we have more than one diploma. And so it may be that some flexibility is required in that disposition, because a child may, or a young person may not, that may not be realistic for them, especially given their circumstances. But I will note too here that under the federal law, a child with an IEP is entitled to maintain that IEP until the year they turn 22. unless they've already graduated with a regular diploma. So there is an extended timeline to be able to get a regular diploma. And I have seen children with intellectual disability graduate with regular diplomas. It takes a ton of support, but I've seen it happen, and it's sort of amazing. There are remarkable, talented teachers in our schools. I know you all know that, and some of them are able to support kids to independence. And the kid that I was just referring to that has intellectual disability and got a regular diploma was also involved in juvenile justice. But that diploma, so proud of himself. It really was this connection to a more independent life, and also the school that provided him services. If you could see this kid, he would come to his IEP meeting telling us what he was learning at school and how he was applying it in his part-time job. So earnest, and really just needed the tools. And the schools, they gave him those tools, and he has a better life because his program was so individualized to support him. It can be done. So we have to, all pitch in and do our part.
There's another question here. What work has been done to address or prevent racial disparities in both access to special ed resources and the role of implicit bias impacting students of color?
So that different states are more and less engaged in that process. So I refer you to your state educational agency to see what your state is doing to address the issues of implicit bias in education systems, and also disproportionality. That is something that the IDEA has provisions to address disproportionality in special education, and I refer you, to the IDEA to learn more about that. But it's really the states that I think are doing the heavy lift on that right now. I think that there's an increasing awareness of disparity in education. I know that there's a civil rights project at UCLA with Dr. Dan Lowson. I think he's a doctor, where they're looking at civil rights data on disparities in discipline. And it's shocking. And so some states are taking that and adjusting their discipline to respond to those concerns. And there's things that different districts and different states are doing to address it, including writing up new codes of conduct. Metro Nashville Public Schools published a new code of conduct in, I think, 2016, with the help of a project out of the Annenberg Foundation, meant to address specifically the disparity and discipline in MNPS. And so you'll see just projects coming up here and there and pushing the needle, and things are changing, and I'm glad that they are, because disparity, it's a real issue.
And I also just want to plug here, again, the School Justice Partnership, because that's what prosecutors can be involved with law enforcement in the school. We're coming up with criteria to say we're not going to refer these cases to school, rather to juvenile court. And if you can make some offenses, we're not referring first fights, for example. The first time someone's in a fight at school, we're not referring those to juvenile court. And you do that across the board, then that can have racial impact as well, because you're saying it's not by the child, it's by the complaint. And so there's been a lot of success in justice partnerships in eliminating racial bias by saying certain offenses won't be referred to court. So if you want to email me, I can send you an example or model justice agreement that would help with implicit bias in school, at least school referrals to juvenile courts. All right, we have another question here. For courts with psychologists to do evaluations, are the psychologists held to standards under IDEA?
Yes, so the school psychologists will be following the criteria of the IDEA when they're examining the child's measurements, the child's assessments. When they're looking at those assessments, they're also looking at the criteria. Now, that's not to say that sometimes individual LEAs, local education agencies, those are school districts, don't have psychologists that misinterpret the criteria or maybe haven't been trained to know that they're supposed to be doing that. I'm sure mistakes happen, but yes, school psychologists should be looking at the criteria and comparing that to the assessment data to make recommendations in their evaluation regarding eligibility.
All right, we're getting down to the bottom of the questions here, Dr. Mason. Let's just do more, or one or two more. This question is, can a parent who refuses to consent to having their child receive education services, can anyone file an educational neglect petition against that parent?
No, I mean, that's their right under the idea. I mean, they can. I mean, they can probably file the petition, but the idea gives them that right. So, you know, that exercise of that right can't be the foundation for neglect, in my view.
Got it. Here, just another question, and we've gotten so many awesome questions. I think it's very helpful for the audience. This question is it possible for a student to graduate from high school from a self-contained special education class and still obtain a Regents diploma? I understood that special education could severely hinder a student's ability to be admitted to four-year colleges afterwards.
So the Regents diploma, I know that's New York specific. And so I think we're getting a question about some state categories. Let's see if I can find the question, because I was thinking about New York and the Regents diploma while you were talking. Well, I guess I can't see it. But anyway, the question was, are children without, or young people without typical high school diplomas able to apply to four-year colleges? That's the question. And that's going to vary state by state. So if that is the question, and I think it is, that's going to vary state by state. In Tennessee, there's specific coursework that is required in order to be admitted directly to a four-year institution. And that's the four-year institutions have requirements. And so knowing what's required on that four-year institution side and what's offered in a particular diploma and figuring out where that matchup is, but that's going to vary by state. For instance, when I said, you know, in North Carolina, there's this occupational diploma offered to kids that has in it a required component of work hours, which is so critical for our students maybe that have intellectual disability or autism. Having opportunities to work and be paid is so critical, because we know that work, you know, prior to finishing high school is a great predictor of work after high school, of the ability to work after high school. So developing those skills for some kids is absolutely critical. But that child didn't take, you know, 2 years of foreign language. And so applying to a four-year school won't be a possibility. But it's a regular diploma. It's just not a diploma that transcript's going to support to, you know, four-year college admission.
I have another question. Would a substance abuse diagnosis qualify as OHI?
Okay, so I was going to go back to the criteria for other health impairment. And so the criteria for other health impairment, well, first of all, under Section 504, substance abuse never, like, that's not an impairment under Section 504. Under other health impairment, it's not a disability that's a constant disability. The child, you know, if the child stops taking medications, or not medications, abusing substances, the child would no longer need the support, and so it wouldn't support eligibility. And I'm looking for specifically the criteria, because I saw that question coming up and I wanted to pull up the criteria so I could answer it with the criteria. So if you want to ask another question, I'll come back to that.
Okay. I think we have a comment here that would be good. Some organizations are teaming up with school systems to implement restorative justice programs to avoid having youth referred to public safety officers at school and courts. Is Tennessee considering implementing more restorative justice and diversion programs to avoid adjudicating students who have had trauma due to removal from their home or due to abuse or neglect?
So I think that that's wonderful. Let me see, I missed the last part of that question.
Is Tennessee considering implementing more restorative justice and diversion programs to avoid educating students who have had trauma due to removal from their home or abuse and neglect?
I don't know what the state is looking at right now, but district to district, I think they're considering intervention, considering support, and you'll find some of those considerations in student codes of conduct by school districts. They'll provide policies that are restorative in nature. Davidson County MNPS tends to try to support that restorative piece, and so our juvenile court also is trying to support that restorative piece. So I would, and I'm not aware of the state pushing any intervention right now specifically that's required. Of course, districts across our state, like districts across yours, are in flux right now because COVID is causing some schools to run at half capacity, no capacity, or under constant, quarantine of students. So things are really messy right now. But in general, I think that is on the radar of a lot of individual districts in our state, and individual districts are pushing that work forward.
We have a question here. If a court mental health evaluation finds that the child is not in the right setting, can the evaluation recommend the school evaluate to find a more appropriate setting?
Yes. Yeah. So that's a great strategy. If you've got a kid that's not making any progress or not making adequate progress with their individualized education program, and you want to figure out what supports and services are needed to help that child make progress, an evaluation with recommendations would be really useful. Because you'd be able to have all that information kind of in one place, the school psychologist that's able to gather teacher observation and be able to gather assessment information and be able to put that together to say, well, this has worked, maybe this will work. Or, we notice that the child is able to make progress when they're one-on-one, when they have an individual teacher. I've definitely had students like that, only made progress one-on-one. And sometimes if that's what the child needs in order to make progress, then that's what we call FAPE, a free and appropriate public education. That's what we have to be able to provide that child, in different parts of the school day so that they can make progress, so they can learn how to read, so that they can, learn to function independently. So, yeah.
So a follow-up on that, Dr. Mason, is how would you go about getting that recommendation to the right person in the school system? And are there any concerns about juvenile confidentiality in doing that? A parent can request evaluation. The schools under the law can evaluate. They typically no more than once a year, unless they agree to. But there's a requirement in the law for it's called triennial evaluation. So every student with an IEP should be evaluated every 3 years. So at initial and then every 3 years after that. And then more frequently if it's requested, once a year. And so once a year, if a parent comes in, and asks for that information, asks for that evaluation, that can be done. Now, and I think the request is probably can a prosecutor, can a court official ask for this evaluation if the child maybe has a probation officer. Now, that's, state law to FERPA, the Federal Education Rights and Privacy Act, is implemented whenever you're talking about access to records. But typically, that probation officer is going to have a court order and going to have access to those records. And so they'll see, maybe can see what's in this documentation. We'll be sitting at the IEP team meeting, with the IEP team. And can, propose like, hey, I think we need to look at reevaluating this child because it doesn't look like the child's making progress to me.
I don't know the person's role who asked that question. Know that FERPA is it's always a consideration when you're talking about records. So, and also this individual states will have different guidelines around how to protect a child's educational privacy rights in the school environment. So you also want to be cognizant of what's in your state law and your state procedures for getting records or for, having access to those conversations. But generally, the parent is the person that's requesting that more frequent evaluation. But if a person at an IEP team makes that request or asks for that consideration, then it will be discussed and may indeed, that evaluation may indeed be commenced.
So it seems like the parent probably has a right to that information depending on state law, and then the parent can basically attach that recommendation from the court mental health evaluation to a request for another evaluation.
Yes, well, the parent can definitely do that too. What I was saying is if there's a probation officer that's engaged in the child's case through the court, is part of, it's coming to that IEP, and that's what I see, in my work, probation officers, it's more restorative model, and they're part of that IEP team meeting, and they're able to have input and say, hey, let's talk about this. I don't think this child's making progress. Do we need another evaluation? And the team can decide, yes, the child needs another evaluation. Let's get the paperwork. Let's get it started. And so typically it's that parent request, but it can also come from somebody else that's on the IEP team. And so there's more than one way to request that evaluation, but typically it's going to come from the parent.
Interesting. So in Tennessee, then the probation officer or court counselor can serve as a part of the IEP team.
Mm-hmm. If they're a person with specialized knowledge about that child, then that's the qualification for the IEP team, and they're invited by the school or the parent. Then yeah, and I've been in many IEP meetings with supportive POs that are there to help kids bridge the divide between where they've been and where they're going, and it can be an incredibly supportive role, and our probation officers are typically really well received. I've had probation officers write letters to administrators saying, hey, I think this child qualifies as a child with a disability. I think this needs another look. And so because she had written the letter, there was a basis of knowledge for whether that child had a disability. It wasn't a request for evaluation, but the school should have been at that point known to look a little deeper and maybe talk to the parent, maybe start, considering this. And that child was saved from an expulsion because of the letter that she wrote. Even though she couldn't request the evaluation, she put the school on notice that she suspected the child had a disability. So those POs can, be a powerful force for good in the child's life that they're working with. And, when we think about rehabilitation, juvenile rehabilitation, that's a purpose that POs can serve, and I've certainly seen POs serve in my work.
All right, we're going to fit one last question in the last 2 minutes that we have, and that is, if a delinquent act committed is not on school grounds but involves a disability, can the school be held accountable if services are in place to address the disability?
So if it's not on school grounds, the IEP wouldn't be relevant. It's hard for me, well, as I say this, it's hard for me to imagine that the IEP would be implicated at all if it wasn't on school grounds. But of course, if you've got a kid, I talked about the occupational courses before. If you've got a kid doing their work hours off campus and that IEP is implemented off campus, then there may be special considerations. But in general, I'd say if it's off campus, the IEP isn't implemented, the schools don't have an obligation to kind of reach out into the community, into that child's community, into that child's home to prevent, crime from occurring where they are not. That would be quite a burden, I think, for our teachers in our schools to have to reach into schools and neighborhoods.
All right, that is the end of the question and answers, and I think now William has a few wrap-up items for us.
All right.
want to thank you very, very much, Dr. Mason, for all of your help here today with explaining these complicated laws and helping juveniles across the country, really, with all the participants that we have to understand those laws better. So thank you very much.
Oh, thanks so much for having me. I really enjoyed it, and I really enjoyed the question and answer section at the end. And I'm still like talking and answering questions and trying to find the provision in the statutes that I needed to address the substance abuse issue. It's been kind of challenging, but I will get that information to you, Rachel, and to you, William, so that maybe you can send that out after the fact. I haven't forgotten. I just can't do three things at once. It's never been my highest skill set. So thank you so much for having me.
Thank you, Gary. Totally understand. And thank you to our audience members. I know we're at time, so I do want to just wrap up with a few last minute items just to kind of let our audience know about. Before we conclude, just note to the audience that I am indeed pushing out the files through something here on the file transfer. So if you didn't get a chance to, you should be able to download the items that are associated with today's webinar, including the PowerPoint, a PDF of the PowerPoint, and a group validation form. So for anyone who has had additional people in the room with them that wants to maybe get them to have access to a certificate of attendance for today, you can download that group validation form and get access to that and send that in as well. Please note OJJDP TTA at USDOJ.gov is where you can send in any requests if you need access to those items. Also note that the evaluation link is in the chat. My colleague and co-host put that up, so please, please, please take a moment to fill out that evaluation for today's web event. And if you have any questions about the evaluation, I believe any questions about any type of CLEs related to today's webinar, you can reach out to our colleagues at NDAA and they can help to address any of those questions that you may have. That being said, just one last reminder of our contact information with OJJDP's INTAC is up here on this slide. If you would like to get in contact with the Help Desk or with JuveJust or any upcoming events, please note that the links here will allow you to do so, and you can finish that as well. So thank you very much in advance for contacting us at those avenues there. If you have a training or technical assistance need, you can request assistance via the OJJDP TTA 360 platform. The link to that platform is here. Would you like to get access to any archived webinars? If yes, then please note that you can do so on our YouTube page, and you can contact the OJJDP TTA Help Desk to get access to any of the webinars there as well. In regards to this and all webinars, please note the disclaimer that the opinions, findings, and conclusions or recommendations expressed in this program are a web event are those of the National District Attorney Association and do not necessarily reflect those of the Department of Justice. And then on this slide, please note that we have upcoming events that you can register for. Two events, one coming up related to grant solicitation provided by OJJDP on both the 28th and the 2nd of February. We have another webinar in regards to SROs and social media as well with our colleagues with NDAA. That's coming up on the 3rd, and then a solicitation webinar on the 4th as well. Again, both of those are available and ready for you to register. Two additional webinars, again, with our colleagues with NDAA. Misspoke. These are the two related to the social media. The one on the 3rd is for SRO, but these are available for you to register and take part. Again, these are indeed webinars hosted by the National District Attorneys Association, who you witnessed, who helped to present today's web event. So please note that those are available. On the 10th, we have a webinar with our colleagues with Street Law that's available for you to register and attend there, and another grant solicitation webinar as well on the 11th. Finally, I'm going to share another poll question for individuals to complete as you all file out of the virtual room here. And basically what we want to know is, how do you plan to apply the knowledge that you've learned today? Please note that this poll is multiple choice, so you have an option to where you can select multiple options here. So please take a moment to complete this poll question and let us know how you plan to apply the information that you've learned. Again, this is multiple select, so you can select multiple options here. I'll go ahead and stop our recording there as well. And I'll leave this poll question up